Hello everyone, let's begin with today's video. So as the title itself suggests that I will be talking about electronic evidence in today's video. So it is given in section 61 of the Bharatiya Sakshar Adhiniyam. So first let me give the background about the electronic evidence. So it is a kind of evidence which is produced electronically, and it is produced in the court of law if by two methods, in primary evidence and in secondary evidence. If it has to be produced by primary evidence, then it has to be original, like what is being given in explanation 4 to 7 of section 57 of the BSE, right? So if the evidence is produced through those methods, like satisfying those provisions, if it is falling under those provisions, then that will be considered as primary evidence. And otherwise, if you are producing the electronic evidence under section 61 of the BSE, then 63 of the BSE, my bad, so that will be considered as secondary evidence. So electronic evidence can also be produced by two methods: primary evidence in section 757 explanation 4 to 7, and secondary evidence which is in section 63 of the BSA, right? So as you can see, the section 63 of BSA is quite complex. It belongs around 1.5 pages to 2 pages in the BARE Act. So here my rules come in. So I'm here to break it down into simplest way possible for you guys. So let us begin. So section 63 clause 1, it talks about, basically I will just give you the overview in my language so you can just go through the provision and it will be crystal clear in your head, right? So yes, section 63 clause 1, it talks about the printout or like printout storage of any or of any e-media, electronic media. And yes, so it talks about the printout and in the pen drive and anything else which you are producing through the physical copy. So if you are like many have you have seen in the courtroom also, when there is a CCTV footage in question, or someone wants to produce CCTVs, then they produce the printout of the screenshot of that CCTV footages. So those CCTV footages has to be supported by the certificate of section 63 of the BSA, which we will talk about later. So section 63 applies to when you are producing through the printout of the any media or anything, right? So for producing it has to be satisfied 4 conditions. So it is given in clause 2. Actually it is difficult to carve out, but I will tell you in a simpler way. So the first condition it is device was in lawful custody and used regularly. It should be in lawful custody of the person who is producing it, and it should be used regularly. For example, if I've installed a CCTV cameras in my home, so it will be considered as lawful custody in my name and in the name of family. So my family is in the lawful custody. If someone is coming from back door and stealing the CCTV footage, he is not in the lawful custody. This is about the first point. And second is device was working properly. It should be in regular use, and that is not just that it is broken down, or it is damaged, the device is damaged, and you are just producing the CCTV footages in a broken manner. So it should not be the case. And thirdly, the regular information was being fed into the device. So obviously when it was working properly, regular information was being fed. CCTV is working, so and every time there is something happening, and the CCTV is regularly recorded and stored in the DVR box. So, and fourthly, electronic record produced in the court has information. This is the most sacrosanct thing. It should be having some information about the case. It is not just that you are randomly producing anything. So these 4 conditions have to be satisfied for you to produce the electronic evidence in secondary evidence in section 63 of the BSA. So in the clause 2, the 4 conditions are given. These are that, and in that clause 3 is not at all important, so I'm just leaving it. You can just give it a bare reading, it will be good for you. And fourthly, in clause 4, it talks about the certificate. So 2 certificate needs to be produced, one by the expert. The expert is also given in section 39 clause 2 of the BSA. You can just refer that to. And the other certificate is by the owner. So these 2 certificate, you can find them, the format of these 2 certificate, in the back side of your BARE Act. It is given under the heading the schedule, and part A is applied for the owner, and part B for the expert. So yes, these 2 things. And there is something more crucial which you will find difficult to comprehend, which is the hash value. So many of you are not aware about the hash value. So let me break it down, let me explain you. So hash value is something, the value of particular video or any media or anything which tells about its score. it's a source. Like if you send that video to 100% and 100% edited in their version and modified in their own version, so it will quite be distorted, so it will not look similar. If you just look all the videos from your eyes, but there is something common in that videos, so that is the only the called the hash value. So the full form of hash values is not found on Google, like it is giving different full form in different places. So yes, this is about the hash value. And yes, one case that I will want to discuss about, actually there are three important judgments with regard to this. So firstly, so let us again rewind the hash value thing. So if that is the core identification value of that media, so it is called the hash value. If you are disseminating it to certain persons, its size is changed and its content is also changed, but there is something called hash value, which is the source of it, and that doesn't change. So that is required. I will also tell you the significance of it. It is not just about a technical term, so I discussed with you. When police media uses something in investigation, and if they are transmitting it to different persons for investigation for modification purpose, so to secure the authenticity of that video, we calculated the hash value through software, and in any application you can just calculate it. So while after calculating it, we can know that that media, that any video footage or anything is accurate and is authentic and is same in all the cases. There are actually three cases. Firstly, first case is PV Anwar versus PK Bakshi, which says that for producing the electronic evidence, section 63 of the BSA and corresponding to section 65B of the Indian Evidence Act, that has to be complied with while producing the electronic evidence. And in the another case of Safi Muhammad versus State of Himachal Pradesh, which is the case of 2018 by Supreme Court, they said that requirement of certificate under section 65B is not always mandatory. So which is overruling the previous judgment. But then comes the judgment in 2021 by Supreme Court by the name Arjun Pandit Rao Khotkar versus Kailash Gorante. So it basically says that it revives the previous earlier position which was set by in the Anwar case, and it overruled the Safi Muhammad case. So they said that the certificate under section 63 of the BSA is mandatory required while you produce any electronic evidence. So this is the present position and current position about producing the certificate. So yes, this is all about the section 63 of the BSA, which is the electronic evidence. So right, if you just drop the comment or like the video or subscribe my channel, it will be very encouraging for me to make such videos. And if you find any discrepancy, you haven't understand anything, or you want me to improve on any aspect, please do drop a comment. I will be more happy to read it and reply in the same. So yes, thank you so much for watching video. I'm glad.